morning to all of you. Dear friends and colleagues, this is Dr. Saravana Kumar, National Secretary for Society for Emergency Medicine India. And it's my pleasure to be here today with you all in this wonderful Semicon event. I'm going to be talking about communication and safety and its medico-legal implications in emergency department. There are multiple questions when it comes to medico-legal issues in emergency department. For example, should I give a death certificate or not? Should I document DNR? Am I qualified enough to do a certain procedure in ED? Should I inform this particular thing to an attender or not? Should I treat this patient who is not paid? Should I continue to treat this patient who is not willing or the attender is not willing? How do I go about managing this child who is not accompanied by his parents? Should I reveal certain information to the police authorities? Am I breaching certain confidentiality? And how do I manage sexual assault victims? There are multiple questions in our minds. And I congratulate the organizers of Semicon to include this topic as a part of the Semicon 2022, because this is what I call a learning which is not there in your textbooks. This is something which you are expected to practice day in and day out. Unfortunately, none of the books teach you about this. So that's the reason why Society for Emergency Medicine India has come out with a program called Lawyer, where we deal about all those questions in our mind in depth. And I'll talk about it a little later. But for today's talk, we're going to limiting ourselves to the importance of communication in an emergency department and also safety of patients in emergency department and what is the medico-legal implications of the same. So when we talk about communication in an emergency department, there are only 4 ways you're going to communicate. One is oral communication with your patients. Number 2 is your documentation. Number 3, which is your consent, is a bit more specialized form of communication. I'll talk about it a little later. And the 4th one is the privileged communication which you have with your patients, or it's a privileged relationship which you have with your patients. So let's deal about it one after the other. Clearly, when it comes to the proof of your oral communication, it is very clear. Documentation, in fact, a written documentation is a clear proof for your verbal communication. So let's be very clear. In a court of law, for you to prove that you have communicated something with your patients, a clear documentation is an absolute must. So clearly, we are not going to be focusing much on oral communications. As you all know now, that's not going to be valid in a court of law. So let's quickly jump over to documentation. So here is a question which comes to your mind when it comes to documentation. Should I treat the patient first or should I document first? Clearly, this is settled very clearly in the court of law that in case of an emergency, the treatment of the patient, the resuscitation, the first aid always takes priority before any sort of a documentation, especially in an emergency department. So you don't have to really worry that if a document is delayed, is there going to be any implications of the same? Clearly not. So this was well settled in the case Paramanand Katara versus Union of India, where the duty of every doctor in case of an emergency is clearly to provide the emergency care. And that duty is clearly, as per law, is defined as total, absolute, and paramount. It's a very clearly defined order where every doctor, be it from a private sector or from a public sector, when he sees an emergency case, is supposed to provide emergency care, which is his total, absolute, and paramount duty. I'm going to take you through a short ED scenario to understand the importance of documentation, especially in ED. The 70-year-old patient with shock in emergency room, there was a cardiac arrest. There was no return of spontaneous circulation. Clearly, it's a failed resuscitation effort. The doctors tried their best. Unfortunately, the patient didn't survive. And attenders have raised a case in this particular incident, BK, so this is Alchemist Hospital, where they said We didn't evidence any bill for atropine, and we assume that's not used in resuscitation, that's not documented anywhere. So we assume the CPR or the resuscitation is not appropriate, and they raised a negligent case against the emergency doctors. Interestingly, in this case, the doctors were found not guilty because clearly they have documented in the case sheet that ACLS protocol was followed during resuscitation, and using atropine is a part of ACLS protocol. So a mere misentry, or when they forgot to raise it in the bill, it doesn't mean negligent. So the courts have actually said it's not negligent. That's because the documentation was very, very clear that an ACLS protocol was followed during resuscitation. Here is another case which I want to tell you guys as well. This is a case of acute coronary syndrome. It was a cardiac arrest, and the doctors have tried resuscitating, could not. At the end of resuscitation, once the patient was declared dead, the case sheet was documented, which I'm sure most of us do routinely in our emergency department. Here, the case was alleged such that the time of documentation and the time of death declared, which we all know at the end of resuscitation, you sit and write your notes. We enter the time when you start your notes, and clearly you also know the time of death. It's almost very similar to the same time. We enter that, and the attenders alleged that no resuscitation was carried out. As you can see from the notes, the time of notes entry and the time of declaration of death is same. And the courts clearly ruled there is no negligence here in this Praveen Gandhi versus Singla case in 2014 in National Consumer Commission, where the courts have clearly said it is only possible for the doctors to enter the notes after providing treatment. And during such documentations, they have entered the time of when they actually return those documents and time of death. It doesn't mean that no resuscitation was provided. And this documentation was done after providing first aid or after providing resuscitation, which is the right thing to do. So the doctors were held not negligent. So clearly you can see from these two cases, courts are also understanding, and they also know in case of an emergency, the patient takes priority. Sometimes we do miss writing certain notes. We do delay writing certain notes. So it doesn't mean that we can avoid these notes completely. But however, please ensure that whenever you complete your resuscitation, you put your notes immediately. So this is what I wanted to re-emphasize when it comes to documentation in ED. The documentation can follow management. Courts are generally lenient on formalities, but never on management. And emergency treatment is absolute and paramount. So coming to the privileged communication, here I want to discuss a case with you. Assuming this is a case which was brought to the emergency department with fever for evaluation, and as a part of evaluation, you have found out that the patient is HIV positive through your test. The fiancé who is accompanying the patient wants to know the report. The question here is, can we disclose this or not? Here you may think about privileged communication. This was an exact similar case in Mr. X versus Hospital Z. Whether to disclose certain information to the wife or parents or relatives. Not so much parents, but clearly, yeah, in certain cases, yes. And here the doctor actually went ahead and disclosed the HIV status to the fiancé, and because of which the marriage got called off. And now the patient has raised a complaint saying the doctor has actually breached his responsibility because this was supposed to be a privileged information which only he is supposed to know. And now he has disclosed that, and because of which his marriage is now stopped. The courts clearly opine that any communication which may harm others, or in other terms, any information which has an implication of the close relative, the doctor is free to disclose. So the doctor was held not negligent. As the courts have opined, right to privacy is not absolute, lawfully restricted for prevention of crime, disorder, or protection of health or morals, or rights and freedom of others. In this particular case, if the doctor has not disclosed, there is highly likely the fiancé would have contracted HIV. So that's a reason why the doctor disclosed the information, and clearly courts have not held the doctor responsible for the same. So we need to understand when we shall disclose information. You can disclose any information with consent whenever there is a court investigation, whenever there are other doctors involved in the care where you want to share certain information for clinical diagnosis and proceeding. It's a legal duty to disclose if it's a notifiable communicable disease, or in case of an emergency, if the court asks for it. For research and education purposes, you can disclose this information, but without revealing any identity which might lead back to the patient, or with consent. For example, a photograph but covering the face is completely allowed, or with the consent, and obviously with insurance companies. And when it comes to HIV information, it's very clearly settled that it's up to the doctor's discretion. So let's quickly move on to the next form of communication, which is consent in emergency. As we all saw through permanent Katara, which is Union of Indian case, consent is necessary, but clearly the treatment for emergency patients is much more important than the consent. The doctor is duty bound in case of an emergency, and no formalities, including consent, is necessary if it interferes with the first aid or management. So clearly, in case of a life-threatening emergency, you can proceed by treating the patient first, even without a consent. Let's be very, very clear. This is in case of an emergency in a life-threatening situation, you can proceed treating without a consent. It's been well settled in many cases as well. One good example is Thomas versus Elisa case, where the doctors said we didn't operate an appendicitis, for example, because the patient has not given consent, but the courts have actually ruled doctors negligent because a burst appendix is actually an emergency where patients need not, or where doctor need not take consent to operate to save a life. So let's quickly move on to some of the issues with regards to patient safety during emergency. We all know any patient being transferred internally or externally, example by an ambulance specifically, needs to be accompanied. This is one interesting case in Tamil Nadu, Dr. Sakti versus Krishnan 2012. This was a critical patient who needs transfer to another hospital. Unfortunately, there was no ambulance available. The doctor has sent the patient by a taxi. He didn't write any transfer notes. It was a dire emergency. And the doctor, in fact, went in his own car behind the taxi till the patient reached the other hospital. So the attenders alleged negligence here, saying the patient should have been shifted by ambulance and there is no notes, so no treatment was provided. Interestingly, courts have ruled out that it's not negligent because at least here, the intent to see that patient reaches safely to another hospital is there because the doctor has accompanied or in fact went in another car behind. And unfortunately, he didn't get an ambulance and there was no time to write a transfer notes because it was an emergency. And this was not something which you can handle in that particular situation or a hospital. So he has taken his best efforts at that point in time to move the patient to a better hospital. So clearly, you can see there's an intent of the doctor to provide the best possible care at that point in time. And in this situation, the best possible way is to move him to the best hospital. And he also tried his best to accompany so that there's no untoward incidents on the way, which proves that he is for the patient and he wants to treat the patient. So the doctor was held not negligent. So these are one-off cases where I'm trying to tell you that when it comes to emergency, the courts are extremely lenient because they know it's not going to be straightforward and you cannot expect a state consent or a documentation. So this is another patient. Look at this scenario. So you have a case of RTA, head injury, pneumothorax. You have diagnosed, intubated, treated. Unfortunately, the patient dies and postmortem reveals a shattered liver. You have missed a case of blunt abdominal injury in an emergency situation. What do you think? Are we liable for the same? It was again well settled in many cases that error of judgment is not negligence. More the emergency, the more the possibility of error. Only reckless disregard to the patient's interest and greater deviation from the accepted practice constitutes negligence. So in case of an emergency, error of judgments do happen. We might misdiagnose, but that's not considered negligence. So what do you infer from all this information I have given you so far? Is generally courts are much more lenient when it comes to emergency situations. But clearly, it does not mean that we take it for granted. We still need to get a consent. Unless it's a dire emergency where you are not able to get a consent, please proceed. And you do have to document, but that's after you provide appropriate emergency care. So in summary, emergency treatment is much more important than documentation. Of course, documentation is also important, but after emergency care, your proof of communication is only documentation. Document once the emergency is being managed. Clearly, more than the consent, the life-saving act is much more important. So you have acted in the interest of the patient to save the life without a consent, you are spared. But if you have waited, delayed treatment because you didn't get a consent, then the courts might consider that as a negligence. Privileged information, kindly think before you disclose. There are certain informations, and in certain situations you can disclose, and always provide first aid before safe transfer of these patients. I think with this briefly, we have touched about the communication part and safety part in the given time, but clearly this is a huge area or a subject of interest to many of us. So what I suggest or request or recommend is clearly all the residents like you how to undergo this training program in law ER so that you can understand these case laws much more in deeper, and also the logic behind any of these decisions and judgments. And also there are many areas in emergency department we face when it comes to medical legal issues. This particular course will give you a detailed knowledge on the same. With this, let me stop my lecture, and best wishes to all of you. Thank you so much.